All right, let's talk more about this with International Justice Cluster lead at the Southern African Litigation Centre, Dr. Atilla Kisla. Doc, good to have you, and thank you very much for coming on this afternoon. The interception is taking place in the Mediterranean Sea, about 70 to 80 nautical miles off the Gazan coast. My understanding is that these are international waters, therefore governed by the United Nations Convention on Law of the Sea. What does this mean, and what does it say?
So that distance that you just mentioned, the 70 to 80 nautical miles out, is very critical, especially under maritime law and international law in this context. So while a state like Israel might claim sovereignty with broader powers within the 12 nautical mile radius, which is roughly 22 kilometers, which is called the territorial sea, outside that, its actions are bound, of course, by international law, but under strict legal requirements, especially if we consider actions as we have seen now just recently. So in that regard, if we look beyond the 12 nautical mile radius, and 70 to 80 falls within that scope, Israel can only, under very certain and specific scenarios, act as it has done. So in that regard, such legal exceptions or legal basis is derived from cases like, for instance, in a case of piracy, slave trade, or false flagging. None of these cases seem to be met in this case, so which indicates that this kind of conduct was unlawful under international law. And as you pointed out, the basic rule under the UN Convention on the Law of the Sea is the flag states have the exclusive jurisdiction over these vessels in the high seas.
So you're saying that the principle of state sovereignty only kicks in at about 12 nautical miles, which is about 20 kilometers. Then you're saying Israel could have then claimed that their sovereignty was being threatened.
Exactly. They have broader sovereignty rights, and within that 12 nautical mile radius, they whatever the justification might be in that scenario, they could claim a basis for these kind of conducts. But in this scenario, because we are so wide out from the coast, 70 to 80 nautical miles, that 12 nautical mile radius and those kind of rights don't apply in this case.
All right. Now, as far as then the civilian vessels, are they free at sea? Is that the core principle that governs their movement there? Are they free to travel out there at sea as far as international law is concerned?
Exactly. And especially because we are dealing in this case with a flotilla that was delivering humanitarian aid, we have to also look at international humanitarian law. There are certain instances, again, under which a blockade might be lawful. However, as we know by now, international humanitarian law has very strict limitations and circumstances under which such acts could be lawful. However, if a blockade, as we have seen by Israel, the blockade of Gaza, has the purpose of or effect of starving civilians and not allowing humanitarian relief into Gaza, if that is the only purpose, that kind of blockade is unlawful. And once we have an unlawful blockade, boarding these boats or crashing into them cannot become lawful.
Yeah. So would you say now by this blockade and arrest, a dispute has arisen and therefore would need a resolution, and which court will be able to intervene in this matter and bring a resolution?
It depends. This could be a matter that can be brought before as we know, the International Court of Justice, with reference to the specific treaties and instruments of international law. But I think, especially if we look at the International Court of Justice, especially because the the provisional measures by the ICJ in the case of South Africa against Israel speak to humanitarian aid and allowing the access of humanitarian aid, I think even the judges in that case will certainly pay attention to what is happening here and what kind of conduct was and how Israel conducted itself, as it is speaking directly to the obligations that derive from these ICJ provisional measures.
Do we have case law for this? I mean, especially since Israel had intercepted the Madeleine earlier in the year, what could have come out of that particular process?
I'm not aware of any case law on the particular matter like this, in a situation and such a scenario like this. But we have seen that Israel has done over various, over almost a decade, blocking of humanitarian aid boats. And this is unfortunately and sadly nothing new, and this tactic is not new. So we'll have to see how they act, how they will treat the individuals they have detained. Detained in this case. So in some cases, these individuals were quickly deported, but it could also be that the Israeli authorities will come up with some domestic law charges.
Now, as far as Gaza is concerned, I mean, what is the status of Israel there? I mean, is it an occupying power? Does Israel control all access to Gaza, whether by land, whether by air, whether by sea? And then, therefore, they are the only ones that can give permission for any vessel to enter Gaza?
So in terms of the occupation by Israel in Gaza, the International Court of Justice was very clear that the occupation by Israel is unlawful. So any conduct and any kind of action that relates to the occupation of Gaza, especially, is unlawful in this context. And the International Court of Justice has called on also third states to not support Israel, or not to provide any support that could maintain or support the occupation in Gaza.
Now, we've seen earlier, I suppose, in the previous year, for example, the United States building its own floating pier off the coast to deliver aid in 2024. This was allowed and was not blocked. What then does that mean as far as the other boats that are now being blocked? Does it mean that Israel only recognizes the United States as the only country that can bring humanitarian aid in Gaza?
It's like I'm aware of the pier that had been set up by the U.S. I'm not sure what the current situation of the Israeli government is in terms of providing any aid over the sea. However, we have seen that also the concept of the pier was not sufficient to provide the people in Gaza with sufficient humanitarian relief. So in that regard, it clearly shows that the humanitarian relief that's going into Gaza is not sufficient, and that Israel appears to continue to break international law.
So, Dr. Atilla, does that mean then where we sit right now, there is no legal mechanism that exists to hold a state accountable for such interception?
Accountability like I said, could be reached through mechanisms like the International Court of Justice. If a new case could be brought up, or if this could be mentioned in the case of South Africa against Israel, as far as it relates to the obligations that derive from the provisional measures or the Genocide Convention. So that could be certainly an avenue. But beyond that, I think it's also important for other states, individual states, to build up pressure and advocate for further sanctions or embargoes, to build up the pressure so that Israel comes around and cannot just merely continue to break international law or not consider international law at all.
Yeah, but we've got other countries. It's not just South Africa. It's Brazil, it's United States represented there, Turkey, it's Jordan, it's Qatar, it's Lebanon, it's France, it's Syria, Spain, Colombia, Iran, Ghana, Palestine, United Kingdom, Yemen. And there's a lot of countries that would have been involved in this particular flotilla. Do they bring a joint challenge at the ICJ, or should each and every individual country represented in this flotilla then bring a matter to the International Court of Justice?
I'm not aware of any coordinated effort so far, but I think what is important here, and especially when we also talk about the bindingness and enforcement of international law and the relevance of international law, I think just ignoring it doesn't erase international law. So states can still react with consequences, individually or as a group, whether that's diplomatic isolation or sanctions or embargoes, like I said. For international, if we look at international law as a whole right now, the danger is imminent. So that's why consequences and actions by all these states are required, and I'm sure the relevant stakeholders within these countries will try to build up pressure that hopefully translates into the diplomatic relations with Israel.
Dr. Atilla Kisla, appreciate your time. International Justice Cluster Lead at the Southern African Litigation Centre there with that analysis.